Hello, and welcome to our periodic webinar series at the Syracuse Technology Commercialization Law Program and the Syracuse Intellectual Property Law Institute. This is Professor Shubha Ghosh of Syracuse University College of Law, and it's my real pleasure to introduce Professor Zvi Rosen of Southern Illinois University School of Law, where he teaches a range of courses, real property, intellectual property, business law. He's done work in bankruptcy law as well as in intellectual property. And he had a wonderful contribution on Paris versus Hexheimer, a late 19th century Supreme Court case for our Syracuse University Law Review's symposium on forgotten intellectual property law cases. And that case appeared again yesterday a little bit in the Oracle versus Google oral argument before the Supreme Court. And today he's here to talk about his book chapter in the shadow of the trademark cases, which will be appearing in the forthcoming book from Elgar, Forgotten Intellectual Property Law. So thank you, Professor Rosen, for spending some time with us. And please tell us about your chapter. It's really an interesting look at trademark law, jurisdiction, constitutional law, and some aspects of federal courts.
Thank you. Yeah, I'm really excited for the book. It's looking really great. Let me throw up my few little slides here and talk about it. So let's go through that. Okay, let's start from the beginning. So yeah, so my chapter called In a Shadow of a Trademark Cases. This is meant to be sort of a sequel to my 2009 article, In Search of a Trademark Cases. Funny how time flies. I am Zvi Rosen, and as mentioned, I'm an assistant professor of Southern Illinois University School of Law. So hopefully my article rather, In Search of a Trademark Cases, is largely about this background, which is that the first federal trademark law became law in 1870. Now, of course, we've had federal copyright and patent law since 1790, and the Constitution mentions copyright and patent law in terms of giving protection to authors and inventors for their rights and discoveries. But it doesn't mention trademarks. Thomas Jefferson did talk a little bit about a federal trademarks law, but it didn't go anywhere. And it didn't end up happening until 1870. It was really only passed because we had a number of new treaties with foreign powers for reciprocal protection of trademarks. And so we passed this law in 1870 to give effect to those. In 1876, criminal remedies were added to the federal trademarks law. But in 1878, a federal court in Wisconsin found that the federal trademark law was unconstitutional, that Congress lacked the power to pass a general trademark law. Now, the 1870 law was not limited to use in commerce or anything like that. It was just a straightforward registration-based system with no requirement of use. And that this went up to the US Supreme Court, actually a different case, and actually started to consolidate cases, and a reporter called them trademark cases. At the time, it was United States versus Stephan, et cetera. And the US Supreme Court agreed. And the US Supreme Court struck down the 1870 federal trademark law unanimously, holding that it was not, a trademark was not a writing within the meaning of the Constitution. And because there was no requirement of use in commerce in the law, it couldn't be upheld under a Commerce Clause. There was some mention about whether or not it could be upheld under a treaty power, but the court specifically decided not to address that. And this took us to the 1881 Trademark Act. So we said, oh, we passed all these treaties with foreign powers. Clearly, we have to have something, otherwise we're in violation of our treaty obligations. So they repassed the 1881 Trademark Act. Now, it's largely a copy of the 1870 Act, but now it was limited to use of trademarks in international commerce. When I say international, I mean both with foreign powers and Indian tribes, but in the future, I'll just say foreign to mean that. There's actually an interesting question about what the law was premised on, whether it was the treaty power or it was sometimes called a foreign commerce power. Congress itself wasn't entirely clear, and my earlier article in Search of Trademark Cases really goes into this more. Mm-hmm. There are three relevant parts to this law for purposes going forward, and ultimately would doom the 1881 Act effectively. So applicants for federal trademark registration had to declare that such trademark is used in commerce with foreign nations or Indian tribes. So to get a registration, you had to declare that it is used in foreign commerce. Secondly, if you wanted an injunction, that was limited to case that you can only get an injunction against wrongful use of a trademark in foreign commerce or commerce of Indian tribes. So any injunction you could get under a federal law in 1881 was limited to foreign commerce. And finally, the Act explicitly gave no jurisdiction to any of the federal courts unless a trademark in controversy is used on a good intended to be transported to a foreign country or in lawful commerce, commercial intercourse with an Indian tribe. So the third part is there's no federal jurisdiction unless the alleged infringement is in foreign commerce as well. And so you have these three clauses of the 1881 Act. And so this goes forward, it's sort of limited. And you start testing the 1881 Act. And what you see very early is that a lot of companies would get a registration by having it so effectively token use of a trademark in international commerce and using that as a basis for a trademark registration. But whether that was enforceable, and you'll recall that you just had to declare it was used in commerce to get a registration. It's a fairly low bar there. But was that actually enforceable? Did it actually give you anything valuable? This takes us to Ryder versus Holt. This is an extremely short Supreme Court case, but actually it's one of those, if you read the actual reporter page, you'll see it's actually meant to be read in concert with Menendez versus Holt, which should be 3-4 pages long. And you're effectively supposed to read it as an addendum to that other case. Now, this was a lawsuit between former business partners regarding trademarks for flour. And this is the actual trademark at issue, La Sabrita flour. And so Stephen Ryder was a Civil War veteran and a former partner at the Holden Company firm. He left the business. He had originated it himself, and Holt sued. So Holt also sued Menendez. Now Menendez it's actually Menendez plural. The Menendez brothers were Spanish nationals who were trading partners of the Holt Company, and Holt sued them as well for trademark infringement. If you look at the record, it's pretty clear that Menendez brothers were brought in for jurisdiction. It doesn't seem they ever actually appeared in the case. There's no real evidence. They're barely mentioned, but they were needed for jurisdictional purposes. But because Ryder was sued separately, Ryder's lawyer sensibly said, wait a minute here. They both live in New York. There's no jurisdiction here. And in any case, he said Ryder's business is only domestic. And so the Supreme Court separately noted, because of trademark and controversy, the Ryder trademark was not used on goods intended to be transported to a foreign country, there was no jurisdiction. And it's just trial court, essentially any federal court. And so effectively, the Supreme Court held that unless goods are being traded in foreign commerce, holders of trademarks would have no relief in federal court. Now, this decision didn't really make much of a splash. There's a couple of reasons why. I think one is simply after the trademark cases where the Supreme Court had held the federal trademark law unconstitutional, this decision, which is law, was actually very encouraging, saying, oh, we actually have something here at least. And that's what I'm saying with a shadow of a trademark case. It's looming over this whole era, this fear of federal trademark law would be struck down. And also, it was just such a short decision appended to a longer decision on different grounds. But I think a lot of people just say, okay, great, we have federal trademark law. It has limitations, fine, let's move forward. And so this case sort of stands there, but becomes important later. It was apparent right away, though, the limitation to foreign commerce was a problem as America rapidly industrialized, as interstate trade became more and more important, and really you have started seeing the beginnings of national brands. And so in essentially every Congress, you see legislation introduced to include trademarks using interstate commerce in the federal law. Never actually became law, though. In 1898, Congress appointed 3 commissioners to prepare a report on trademark law. In 1900, a final report was issued. This is a very, very lengthy report. And the majority recommended what we now think of as a registration system for trademarks, which a lot of other countries have, but the US doesn't have, which is basically you register for it and then you own it. And there's no specific requirement of use, or if there is, it's more of a way to invalidate it as opposed to a requirement of getting it. But one commissioner, Arthur Philip Greeley, issued a minority report. What he recommended was largely continuing the use-based system that America already had, but including use in interstate commerce along with foreign commerce. So the report is very interesting. Greeley's section is very important because he really defends the Commerce Clause as being a basis for trademark law. And that was important going forward, but there wasn't immediate action. Instead, you would need another crisis to force that. So there was a lot of thought that the crisis would be Elgin National Watch Company versus the Illinois Watch Case Company. So the Elgin National Watch Company was the largest watch company in, I'm pretty sure, America, and I think even the world at the time. It was based in Elgin, Illinois, and back in the day, the watch was the actual mechanical part of a watch. You buy the watch case separately. So the Illinois Watch Case Company was a separate company, and they moved their factory to Elgin, Illinois, which of course is the same town a watch company owned. They began selling watch cases called Elgin Giant and Elgin Pride, even though they were not the Elgin National Watch Company. However, they were also based in Elgin. Illinois Watch Case, in addition to other arguments, and the case is known for us for other reasons, but has their federal jurisdiction. And indeed, if you look at the last part of the 1881 Act, the 1881 Act explicitly did not give jurisdiction to any federal court in an action between the citizens of the same state unless a trademark is intended to be used in foreign commerce. So Illinois Watch Case said, wait a minute, the court has no jurisdiction. Why are we here? And interestingly, and this is a weird move, but I think the court really didn't want to address it, because both the constitutionality of the 1881 Act and federal jurisdiction were both addressed in a motion to dismiss. The motion to dismiss was continued on. They said, let's hear the case, but the question was continued. The Supreme Court focused on geographically descriptive marks and held that because a mark is geographically descriptive, is not a Elgin National Watch is not a valid trademark. But obviously no longer the law, but valid decision at the time. They refrained from any discussion of whether they had jurisdiction to hear the case. Really kind of a weird holding conceptually, and it tells you that the court really didn't want to address this. But just 2 years later, we didn't have a choice. Disputes between 2 pharmaceutical companies over a similar name for an identical product. This time the companies are based in different states. And in this case, the 7th Circuit found the mark was descriptive. I've talked to a couple of people who are knowledgeable about pharmacy, and what they've said is, yeah, this is descriptive, if not generic, from a professional standpoint for this basically pancreas extract. But Warner appealed to the United States Supreme Court, and there was an interesting thing where the Circuit Courts of Appeal were only created in 1891 by the Evarts Act, which up until that point, the Circuit Courts were actually trial courts. And in fact, in this case, it was heard by the Circuit Court for Illinois, then the Circuit Court and then the Circuit Court of Appeals. So there were two, which existed until I think 1905, that sort of dual circuit system. But under the law of the time, decisions of the Circuit Courts of Appeal were final if they were premised on diversity jurisdiction. So if jurisdiction was based on citizens being from different states, the decision of the Circuit Court was final. And so either, accordingly, if this is based on common law unfair competition, then there's no appeal to the Supreme Court. They have to rely on federal question jurisdiction from a trademark law. This trademark, since two pretty oddly token sales of this to Australia in 1882. I don't have evidence of this, but I'm guessing this is probably a system a lot of people use, where someone in Australia said, "Sell us a couple of items and pay us a fee. You can say you have foreign use."
So Zvi, you're saying that this, for the diversity jurisdiction, then are you saying this was based then on the, just to make sure I understand, this was based on common law trademark or state trademark law?
Well, they argued both, but
they argued both. Okay.
Yeah, they argued it was state unfair competition and state trademark law.
Okay.
And argued federal question, but they couldn't get to the Supreme Court unless they had federal question.
I see.
Because of 1891 Judiciary Act that created federal courts of appeal.
Oh, okay, got it. Okay.
And the Supreme Court says the 1881 Act could obviously only be violated if the actual infringement was in commerce. It didn't matter that you had sold a copy internationally at some point to get registration. You couldn't bring an action to enforce your rights under the federal trademark law unless the actual infringement was in foreign commerce. And what they effectively said, therefore, is that there is no domestic federal trademark law. You have to rely on state trademark law and state unfair competition law. And that got people's attention. That was clearly a problem. I have a little editorial from the Washington Post here about the reprint called Trademark Troubles. And they call this a rather startling condition of affairs. And a new law was really a priority after this. And you start seeing some very rapid moves, both majority minority views from that report from 1900 that I mentioned became bills. And then Representative Boinja, I believe is how you pronounce it, he was, I think, the chair of the Judiciary of the Committee of Patents. And he basically wrote up a synthesis bill, still largely based on the minority bill, aka the Greeley bill. And the Committee on Patents reported it. Shortly after it was reported, I think we see this was reported December 14th of 1904. It became law February 20th, I believe, of 1905. So Congress was not in session for a lot of time after the Warner decision. The Congress actually moved really quickly. Once this was passed, the commercial community said, wait a minute here. If we have no federal trademark protection at all, and our previous practice of using these de minimis sales internationally is not enough for a federal registration, then we really need a new law. And you actually saw, in a little tidbit, a lot of scammers pop up after this law saying, oh, your previous federal registration is no good. Let us help you get a new one. Interesting little thing. And it's like Greeley, who was sort of the originator of this bill, spent a while and wrote a pamphlet sort of striking back at these scammers. So you have this new law, all is well, right? Well, we're still in the shadow of the trademark cases. And this fellow Gaines is Old Crow whiskey. If you look, he's in repeated litigation with people over, if you had a kind of whiskey with some kind of bird in its trademark, he would sue you, it seemed. And so Gaines sued next, and Gaines kept losing in his lawsuits. And I think he got sort of sick of it and said, you know what, I'm just going to rely on state copyright law. And so he just said, you know what, let's try torpedo the entire federal trademark law again. And if you see with the Supreme Court, he actually asked the Supreme Court clerk for copies of the briefs from a trademark cases almost 30 years earlier. And the briefs really talk all about the issue of whether Congress has a power under a Commerce Clause to legislate under for trademark law. I mean, really, the briefs go into great depth on this, and you're sort of prepared for this constitutional battle to relitigate the trademark cases. The Supreme Court did not want to do that. And in a decision that I believe is 2 lines, they dismissed the case for lack of jurisdiction. And they relied on basically they're saying, well, because this is an appeal of an examiner decision, but we have no jurisdiction. Kind of questionable decision, but they're relying on explicit clause in patent law, I think subject to trademark law. I think it was just a way to dodge the issue, but
Hmm.
you know, it's hard to say for certain. You know, there were subsequent cert petitions to try to do the same thing, to re-argue the trademark cases. A paper that talks about them a little bit, but none were accepted. And so in the end, you see the shadow of a trademark case is beginning to lift with the new law, and the Supreme Court basically refusing to address challenges under that grounds. So the last thing I wanted to discuss is sort of a little tidbit of the 1905 Act, because the 1905 Act was really sort of a half measure. There is a famous article, a little bit of William Rogers, where he talks about the expensive futility of the federal trademark law, talking about the 1905 Act. And it was a half measure, but it did add some new clauses. And one of them was a prohibition against registration of immoral and scandalous marks, which of course was before the Supreme Court. Was it really last term? Or was it, I'm not, in the Brunetti case.
Mm-hmm.
Yeah, wow, time flies. So this was added in 1905, and there wasn't really a lot. There was some discussion about where it came from, but when you go into the history of 1905 Act, you start seeing these comments from Arthur Philip Greeley, who wrote it, about why he included it, and he had some great comments actually in the ABA annual meeting about it. So 1905 Act added this, and as I said, it first appeared in Greeley's draft bill in 1900. But if you start looking at William Henry Brown's treatise from 1870, you see this was already a long time patent office practice. And Brown talks about his trademarks for Pipifax bitters, which was a German drink that was sold and manufactured in San Francisco. And it was a non-alcoholic beverage. And they didn't, according to him, right around 1870, when they got this attempt to register, they didn't want to register it. It shows a devil or demon-like creature, which I've shown here, which is straight from register at the patent office.
Hmm.
But they said, you know what? Wait a minute here. He's holding bottles. So this shows us that the bottles of alcohol are bad, and therefore there is a good moral statement here, even though it shows a demon or devil, and accordingly we'll allow it. And so we actually see this was a long-term practice in the patent office beforehand. And actually, what Greeley wanted to do was to limit the examiner discretion from a patent office to limit the grounds on which they could deny a trademark. But one of the ones he explicitly included was this clause that represented a long-time patent office practice. And so that's my book chapter in a nutshell. I'd love to talk about it a little bit.
Yeah, no, that's fascinating. Thank you so much. So let me make sure I understand the court's reasoning. Their view was that since the devil was holding a bottle, it couldn't be immoral. I mean, what was
Yeah,
maybe I'm not
right.
particularly moral or not, but I didn't really understand that logic. But that's
I
interesting.
think they were saying because it was stating a moral lesson about drinking alcohol, it was because it was not. If it was called like satanic absinthe or whatever, and a picture of a grinning devil saying "drink this, it's fun,"
Yeah,
it probably wouldn't have passed muster in 1870. But because it's the devil saying, tempting you to drink, but the actual beverage is non-alcoholic, and it's a reminder of the dangers of drink, it was considered,
I see.
it was not considered immoral.
So the message is kind of like a early tobacco warning.
Exactly. Yeah.
Alcohol is dangerous, but this isn't, sort of.
Yeah. Exactly.
Yeah, interesting.
These
Yeah, that's
non-alcoholic bitters.
well, that's a wonderful paper. You know, one of the things you mentioned about your earlier paper on Parix versus Haxheimer, how that appeared again yesterday in the Oracle versus Google argument regarding copyrightability of APIs. You know, the companion case, the other case that the Supreme Court was hearing yesterday was actually about personal jurisdiction. I mean, this is just obviously kind of an interesting coincidence that now you're talking about jurisdiction issues. So Supreme Court is following you or stalking you or something like that. But that's interesting about the jurisdiction. I mean, the other case yesterday was not in the IP context. It was just a straightforward personal injury case, and as to where the or actually a product liability case. as to whether there be jurisdiction over Ford Motor Company, and what's the basis for that. I'm just surprised we're still arguing that. But then I see how from 1879 to, basically right before World War I, the court was trying to struggle with this basic question about jurisdiction regarding trademarks. Was a lot of this problem having to do with internal debates, having to do with federalism and creating a national body of law versus relying on state law, or is that pretty much what was going on here?
Yeah, well, if you go back to my In Search for Trademark Cases paper, one thing I talk about is how a lot of businesses in 1880 said, you know what, federal trademark protection is not a huge deal for us, except in terms of meeting our treaty obligations. But what they were really concerned about was reciprocal protection. They wanted to make sure foreign governments would enforce their American trademarks because we were enforcing the trademarks of foreigners. And that was never an issue under this act. If you were based in France, the federal courts could enforce your trademark. That was easy. And that really changed. And you see the shift in America over these 20, 25 years, where it was no longer really acceptable to stick with state trademark protection just for domestic products. And it was really increasingly a problem to have to rely on that, get a 50-state registration. I think that parallels the expansion. And you do see a lot of mentions of federalism and federalism type concerns in the 1880 debates. I don't think you see them nearly as much in 1900. I do think it's probably still in the backs of people's minds, but I mean, and it wasn't seen as quite a violation of federalism. Of course, the trademark cases pretty much say that a trademark is not use in commerce. They say it's an incident to commerce, but not use in commerce. And it's dicta, but it's pretty strong dicta, I think. It's for saying what the view was at the time, and that's why the Supreme Court didn't want to hear it in Gaines versus Next. If they had to really address what the Supreme Court said, they'd have to say, well, we were wrong there. I don't think we wanted to do that.
They didn't want to overrule itself. Yeah, interesting. Yeah, and of course, the Commerce Clause is still an issue now. I mean, with the Affordable Care Act, but now, and especially when we saw the revival in the 1990s, with Lopez and Morrison, and I mean, I guess technically the Sebelius case, the court did find a problem with the Commerce Clause. As I say, they bit into the broccoli argument, which I found really shocking, though it was saved on other grounds. But of course, I guess the political economy of that is concern over congressional overreach and over regulation and so forth. I guess what do you have a sense of what the political economy was in the late 19th century, early 20th century about congressional power? I mean, because clearly trademark law, this type of act would have been pro-business. I mean, it's really hard to imagine that as being congressional overreach in the same way that some people characterize, healthcare or the Violence Against Women's Act and things like that.
I think that's right. I think there was some resistance in Congress in 1880. In fact, you have a couple of people who pretty clearly had been on Confederate side in the Civil War talking about how we should limit federal criminal law, and that's why there was no criminal provision in the 1881 Act on federalism grounds. By 1900, I don't think those concerns were as prevalent. I think the general sense was still, I mean, I think this was still past muster under Lopez and all the other cases, but I think the very cramped view of the Commerce Clause that you saw in 1880 was already kind of passé. And the Greeley report basically goes into this and says, we're kind of splitting hairs here. This is clearly part of commerce. And so I think it changed quite a bit, actually.
Yeah, it'd be interesting to look at. I know Professor Farley, Christine Haight Farley at American has written about, as you know, and I think you've cited, and we've talked about the treaty issues that arose in the early 20th century and some of the trademark disputes that came under that. And I'll try to put a link to that work. And I think Professor Ramsey at San Diego has talked about this as well. So it's really interesting to think about what exactly the politics of all of this this was, in terms of, why it, just the hesitancy. And maybe it was just as simple as the court didn't want to overrule its 1879 decision. It was sort of this sort of the pressure of precedent, as you say, the shadow of that was affecting why this took so long to move. And I guess you had the same issue. I'm sorry, go ahead.
I think that, yeah.
No, sorry, I interrupted.
No, I was going to say, I think that, and didn't want to touch it. I think that, until the issue was forced, until it became clear how unsatisfactory the 1881 Act actually was.
Yeah, yeah. I mean, I guess we had sort of a similar issue. I don't know much about the history, and probably you do, or the background with federalizing, creating the 43C cause of action. Federalizing the disparagement of a trademark, or those kinds of actions, the blurring and tarnishment actions. And that didn't happen. And we had the Lanham Act in 1947, and then we didn't have. And then we did have a lot of these types of likelihood of disparagement, likelihood of tarnishment claims under state law, but they didn't get federalized until the 1990s. And it's kind of interesting that took so long. I know Professor Bone has a paper suggesting just how the state bar might have been involved in trying to carve out a space for itself at the state level, as opposed to federal courts. But I mean, it's interesting that that's another example of this kind of slowness of the Congress acting.
Yeah, well, one thing that I go into in the paper a little bit, I didn't talk about too much in this presentation, is that you still have this distinction between technical trademarks and unfair competition,
right?
Where you couldn't register descriptive marks under all of these laws. It's only, I think, in 1920 where they allowed you to register descriptive marks, and so you do have a slow evolution of federal trademark law from protecting technical trademarks to protecting descriptive marks, to a Lanham Act that really expanded that dramatically. And then dilution, I really feel, I don't know how dilution would have looked to people back in the day, because the whole brand economy was still developing, I think
Yeah.
In 1880, you didn't have a lot of national trademarks. Whereas by 1900, you kind of did.
Yeah. I guess that's maybe what happened, is just the part of the parallel story to this, and that's what makes intellectual property interesting, is sort of the cultural, the economic, the business developments that were occurring that probably got reflected in terms of what the economic and legal interests were. That then either went into state law or federal law. So I think there's just a lot here, and I think this is a great contribution to the book. So thank you, as usual. It's a really interesting work. Do you plan to work on this? Are there further developments you're going to go in this direction, or what's the future hold for you with this time of suddenly lots of free time, I guess?
I don't have a lot of free time, but
yeah, I know. And
well, you see, I talk about the next piece I'm doing is on copyright, on copyright examination through history. I talk about that a little bit, but I did joke. I actually presented this, and at the same time as Professor Farley presented her piece, which I think is wonderful.
Mm-hmm.
And at that conference, American University's Trademark Works in Progress colloquium, I sort of half joked that the third part is going to be called Escape from Our Trademark Cases.
Mm-hmm.
And it's going to be, it's basically going to be covering the history of what led to the Lanham Act.
Oh, interesting. Yeah, I think that would be really interesting. I mean, I don't know. I know very little about that. I just kind of have a vague story about national commerce developing and congressional power developing, but even with the Lanham Act, I mean, it was still over a decade between sort of the Commerce Clause cases in the 1930s and Congress finally doing something as opposed to trademarks under the Commerce Clause, right? So,
although isn't it a story that the Lanham Act, the legislative history goes back to, I think, the early 30s or something like that?
So
So I mean, yeah, and of course but also the 1920 Act, which wasn't a full revision, but it was a significant overhaul of the 1905 Act to modernize it.
yeah, yeah,
And so that's gonna be part of it. That'll be part of it also. It might end up being a book itself. I have sort of my in search for trademark cases in this, add a third part and maybe expand this some more and probably have a
yeah.
book.
Yeah. One thing I also found really fascinating, it's worth probably spending a little bit of time on, and I think would also be a great part of your book projects, is this immoral and scandalous mark, how originally it was viewed as a limitation on the USPTO. And of course, the Tam and the Brunetti case viewed as a very expansion of the PTO, right? Sort of a regulation of speech, abridgment of
Yeah.
speech, and not only that, just the inconsistency, how much empirical evidence was brought to bear there, but how the PTO just was completely incompetent as an agency. So it's interesting. How do you think that background history of immoral and scandalous that you talk about affects our understanding of Tam and Brunetti? Is it sort of a combination of sort of the fear or of the agency, or was it just the court just ignoring what those provisions were supposed to be doing originally?
Yeah, well, it's interesting because one of the really cool things I found was, I mean, I was aware of William Henry Brown. So William Henry Brown was a former Civil War general who became perhaps the leading authority on trademarks in this era, and he has a whole section on immoral marks, and because he had, I think, worked at a patent office in 1870,
Mm-hmm.
and he has this fascinating example where he says, and his terminology is a little dated. What he basically says is that a lot of this is about blasphemy and respecting all people, and he has a whole section that they would refuse to register a trademark that insulted a Chinese person.
Yeah.
And I was like, but he was clearly focused on this ideas of respect and comedy, I guess you would say. And so I think that it's interesting in terms of the Tam case. Really, I mean, of course, Brown wrote his first version of this chapter in 1873.
Mm-hmm.
But I think in some ways you could find some support in his view for how the Tam decision ultimately came out, but perhaps not for rationale. I think Brown probably would have disagreed on the rationale, but agreed with the holding, is my guess. It's hard to know,
Yeah, but I'm sorry to interrupt. Yeah, and it gets weird because the whole First Amendment. I don't know what he would think about seeing the First Amendment from his, 19th century, that lens, because that's certainly changed. I imagine he might have more of a Justice Rehnquist view of the First Amendment, that it's meant to be pretty narrow, and probably Justice Rehnquist wouldn't want the First Amendment even go to as far as protecting burning a flag, which I find kind of extreme. But I do understand some of the limitations of the First Amendment as far as commercial speech and so forth. So
Brown was a former general in the Union Army in the Civil War, and so he presumably supported a lot of Lincoln's measures that would totally fall afoul of First Amendment nowadays.
Yeah, interesting. Was he related to the Justice Brown who wrote Plessy versus Ferguson? Or do you know? Or
what wasn't? Don't know. It was
I'm
a
just
very
curious.
common name.
Yeah. There's no reason why, but I was just curious when I saw that, and then
he was certainly still active then. I know the last version of the treatise was 1898. I don't know offhand. That's an interesting question.
Yeah.
I actually should know. Is Justice Brown with an E or no E?
I don't remember. I think it's without an E. And that's also interesting because he was I don't know if he was I don't know if he fought in the Civil War, but he was a Northerner who wrote that opinion. I mean, so it's sort of kind of ironic. I don't know if ironic is even the word, but unexpected, I guess. So
it's way off. That was a crazy case, of course. Of course,
the
whole background of that. But
yeah. No, I'm just curious, especially when you mentioned his, the other Browns, your Brown's version of comedy and respect and so forth. Yeah, so it's interesting.
There's a one factoid about William Henry Brown that I always, it's interesting to keep in mind when you talk about him, and that he was severely wounded fighting for the Union. In fact, he wore a long beard for the rest of his life to sort of hide his injuries. And so it's you sort of imagine someone who probably was very much a man of his time and probably would take umbrage at attempts to roll back what he had suffered for, but that's really, imposing modern views.
Yeah.
Sure.
Yeah. Yeah, it's interesting. It's also interesting that you mentioned the connection to Lincoln. I mean, because there is sort of an interesting, not only Commerce Clause, but just generally what the role of Congress is relative to, the judiciary and the executive branch. And
Yeah.
if I would wonder, just as kind of a naive hypothesis, how much Brown was informed by, probably some view of executive power versus legislative power, and how that might have affected Congress's role here. So, but
well, Brown would have been a political appointee in the Grant administration, right?
Yeah.
She had lost 1970. So
yeah, interesting. Well, thank you, Professor Rosen. This is really fascinating, and I think it's again a great chapter. And I think thank you for taking the time to talk with us. I'm hoping these videos, really support the book as providing another dimension of this. So I really kind of want to market the webinars along with the book, so that this really helps with that regard too. So thank you very much.
Yeah, my pleasure. Thanks so much. It's been great to talk about this.
Yeah, thank you again. So,
okay. All right.
What about? I wanted to stop recording this. So okay, that's what.